Good afternoon. Welcome to Division 4 of the Colorado Court of Appeals. My name is Bob Hawthorne. I'll be presiding over the proceedings this afternoon. To my right is Judge Michael Berger. To my left is Judge Gail Miller. We will be the division deciding the two cases that are before us today at 1:30 and then at 2 p.m. And our first case is People versus Jompp. Am I pronouncing that correctly? Yes, sir. Jompp. And I see Counselor set up and I presume ready to proceed. Do either of you have any questions about our written handout on practice and protocol in the Court of Appeals? No. All right, thank you. I'll remind you that we are now live streaming the oral arguments here, so that if there's anything sensitive or confidential in the case, you should be aware of that. Secondly, I think both of you are experienced appellate attorneys, so you're probably aware of the timing system, and it's self-monitoring these days. Of course, appellant can reserve some time for rebuttal if you wish to do so. As far as those folks in the gallery, if you have a phone or any other device that might go off during the proceedings, please disable that so that it will not interrupt counsel or the court during the arguments. With that, unless there are any other questions, we're ready to proceed, counsel. In People versus Jompp, 15CA0868.
Good afternoon, Your Honor. My name is Sean Lacefield, attorney registration number 35703. I appear on behalf of the appellant, Christopher Jompp. May it please the court. The right to a speedy trial is one of our fundamental rights. To make this right more effective and meaningful, the legislature enacted section 18-1405, which requires the state and the trial court to bring the accused to trial within 6 months of his not guilty plea. When the state seeks to extend this deadline due to the unavailability of a material witness, it has the burden of proving with some certainty a reasonable likelihood that the witness will be available at a later date.
Where does the some certainty test come from?
It's stated in VALLES, or VALLES, and which is 412 Pacific 3rd, 537, decided by this court in 2013.
Do you know where that division got that from? I couldn't find, it just seemed to me, frankly, that division just made it up. I didn't see any prior case law or anything in the statute that would support that. Did you?
You know, I think it's consistent with a reasonable likelihood and the guarantee that we're talking about here. We don't want.
That's it's kind of a stretch, isn't it, to go from reasonable grounds to believe all the way to certainty. And I think you even say something like something even stronger than that in looking at the dictionary. Aren't we kind of stuck, with all respect to our fellow divisions, aren't we kind of stuck with the statutory language?
Well, Your Honor, I think this court should give deference to VALLES. It cites to a previous case, if I recall correctly, which also used that language.
No,
so
it
this
didn't.
isn't.
It didn't. At least when I read it today, it didn't include that language. It just said refer to the reasonable belief standard, reasonable grounds for belief standard.
You know, even if that's, assuming that's correct, I believe that it's consistent with the statutory intent of adhering to the 6-month deadline and not granting an extension of this when we don't know whether the witness is going to be available. We don't want to extend this deadline, which is intended to be, enforced as it's written, based on a whim or hope or something less than a reasonable likelihood that the witness will be available at a later date.
Well, and that, I have a hard time imagining any case in which the prosecution might be able to predict with some certainty that an uncooperative witness or a witness who is intentionally secreting herself or himself from service of process that the prosecution would ever be able to carry that burden of showing that they have some certainty that the witness will appear at a future date. It seems to me that's why the statute would say with reasonable belief, or what does it say? It says reasonable grounds to believe the evidence will be available.
And Your Honor, even if this court were to disagree with the Val's language about some certainty, I still don't think that the evidence here provides reasonable grounds to believe that Ms. Bilsey would be available at a later date. None of those cases that I cite in the opening brief, which the people don't disagree with, necessarily turn on this reasonable certainty language. In fact, they're all cases where the court found that there was a reasonable likelihood that the witness would be available at a later date. And all of the factors that the courts rely on, that the divisions rely on in those cases, none of them are present here. So when you look to the bounds that divisions of this court have set for a trial court's discretion to determine whether a witness, whether the state has proven reasonable grounds to believe a witness will be available at a later date, this case, the facts in this case simply don't fall within the bounds of the trial court's discretion.
Do we defer to the trial court's fact-finding in this regard?
To the extent that there is fact-finding by this trial court, which I assert that there is not, there would be deference. The decision whether to grant the continuance applying those three factors is an abuse of discretion standard. But to the extent that there are factual findings that are necessary for that discretion to be exercised, you would defer to the court's findings.
Isn't abuse of standard, isn't the abuse of, the abuse of discretion standards a pretty tough one for you to meet as well?
Your Honor, based on the divisions of this court interpreting this factor, I respectfully state that I have met that here. We talk about the bounds within which the trial court must exercise its discretion. And we look to the cases from this court and the Supreme Court to define those bounds. And when we look at those cases, we see what those bounds are. And they're found with a cooperating witness, known facts about later availability, circumstances within the state's control, or some combination thereof. None of those factors is present here. And the trial court did not make a finding on this factor. It does not mention it at all in its findings when it's granting the motion to continue,
So
which
are
is
you
itself.
saying- Excuse me,
Sure.
counsel. So are you saying that in order to obtain a continuance, the prosecution would always have to be depending upon or trying to obtain the presence of a cooperative witness?
No, not necessarily. You would also look to whether there's circumstances within the state's control or known facts about later availability. None of these factors are present here.
Well, wasn't there some known factors within the state's control, the ability to seek out-of-state summons for the witness BB that we're talking about? That was within the prosecution's control, and they actually exercised that choice or alternative, I think 3 or 4 times, then they actually did succeed in obtaining the witness.
Well, I respectfully suggest that this court cannot consider the fact that she was later obtained. The court has to look at the facts and circumstances that were known to the trial court at the time that it reached its decision, which was August 22nd of 2014. Ms. Bilsey had not been apprehended on that date. What the court had to go on was her uncooperative interaction with law enforcement, the fact that law enforcement did not know where she was and believed her to be transient, believed her to be moving around. The efforts that they had made in the weeks and months preceding that all were fruitless. They had nothing. The prosecutor said that we thought that we had a pretty good idea about where she was when we had these previous certificates of summons, and they didn't pan out. We believe that she's a bit of a couch surfer, or something of a couch surfer right now, is his representation to the court when he's asking for the continuance on August 22nd.
Mr. Lacefield, before you run out of time, I want to move you along to a different issue, if I may.
Please.
If we agree with you on the escape charge, what does that mean in terms of the remaining sentence? In other
There's
words,
two.
if we vacate or say that the court erroneously sentenced your client on the habitual for the escape charge, we agree with you, where does that leave your client, assuming we reject your other arguments?
I believe it would be to remand for resentencing on the escape charge. And it should be open so that it can be imposed concurrent. The trial court imposed it consecutive at the previous sentencing. But
So
because
we would not remand for resentencing on everything, just on the escape charge?
well, Your Honor, to the extent that the escape conviction and sentence factored into the trial court's sentence as a whole, then I believe it possibly could go to the entire sentence. To the extent that it didn't, the court would look at just the escape sentence and be open to imposing that concurrent or consecutive, because it's not mandatory consecutive.
On that same claim that you have, after the briefs were completed, the legislature amended the statute so that it now reads, a current or prior conviction for escape may not be used for purposes of adjudicating a person an habitual criminal. What, if any, impact does that have on our case today?
Well, Your Honor, I believe it's just further evidence of the legislature's intent. I believe that this question can be answered based on the plain language of the statute for the reasons set forth in the...
So it's not, you don't believe that it's an ambiguous statute, right?
No, I do not believe that it is, but if it were, then the court looks to all the different aids in the statutory interpretation, which I cite in the opening brief, and which the state doesn't challenge.
So you would say, don't look at it, it doesn't matter because the plain language.
If
Where you wanna go.
Well, Your Honor, given that it is an amendment to the statute's plain language, and given that it states in the bill summary that it's clarifying the plain language, then upon further reflection, I believe that it would inform the court's plain language analysis.
So what does the bill summary say? I'm sorry, I didn't see that. And no reason why you would have briefed it, because it hadn't been passed yet.
No problem. It's cited in the Notice of Supplemental Authority. It's the bill summary for House Bill 17-1330 states, this bill clarifies that this prohibition applies to both current and prior convictions for escape and attempt to escape.
Okay, sorry, I guess I missed the supplemental authorities.
That's okay. So if I would just return briefly to the speedy trial point, the court's discretion, the trial court's discretion is not boundless. It is limited by this court's precedent and the factors that this court's precedent have articulated or addressed as to what provides a reasonable likelihood that a witness will be available at a later date. None of those factors are present here. So the state did not meet its burden to prove that factor. Second, and separately, the trial court did not make a finding that there was a reasonable likelihood that Ms. Bilsey would be that BB would be available at a later date. This is error under Marquez v. District Court and People v. Abeta, both of which are Colorado Supreme Court opinions, stating that the trial court must make specific findings on the factors. This is the trial court's duty to uphold the defendant's right to a speedy trial. It's the prosecution's duty and it's the trial court's duty. It's the prosecution's duty to present its evidence, and it's the trial court's burden or duty to hold the state to its burden to prove those factors. I would reserve the remaining time for rebuttal.
Good afternoon, Your Honors. May it please the court, my name is Megan Rasband, registration number 43136, and I represent the people of the state of Colorado. I guess I'll start with the speedy trial issue, and council only addressed the statutory issue, so I'll start with that. Obviously, the factor, I guess, or element that's at issue here is number 3, which is reason to believe that the evidence will be available at a later date. I do agree that Valles does state that the prosecution must prove with some certainty that the unavailable evidence will become available at a later date, but ultimately it's the statute and the statutory language that controls here, and the record supports that the prosecution showed reasonable grounds to believe that Ms. Billsley would be available at a later date. I'd like to briefly touch on the cases that defense counsel cited. Obviously, I think this is a factual determination, and so those cases don't restrict the court from considering other things beyond whether or not the witness is cooperative, if there's a known return date for the witness, things like that. That's just not the facts of this case. The witness here was uncooperative. At points she indicated she would be cooperative, and ultimately they did obtain her presence. I would also state that the trial court's finding that this factor, that the prosecution met, this third factor element, is implicit in its granting of the prosecution's continuance, and that the record itself, there's sufficient information there for this court to find that that factor or element was met.
Do you agree with Mr. Lacefield that the applicable Supreme Court decisions require that the trial court make specific findings as to the reasonable likelihood element of the statute?
I don't, if I'm remembering right, I don't think the Supreme Court cases are that explicit in stating that. The prosecution does need to, I believe the cases say the prosecution needs to present that and show how they've met each of these elements, in the trial court ultimately needs to find that those are met. I think if the trial court is required to do that and didn't here, and there's not sufficient evidence in the record, then it should be remanded for the trial court to then make that finding if this court finds that's something that the trial court was required to do. Second,
Husband,
oh, I'm sorry.
Let me shift gears on you a little bit. Why isn't the question of whether the defendant was in custody, this is the instructional issue, why wasn't that a question for the jury rather than a question to be decided by the judge?
Well, the jury was ultimately able to make that determination based on the escape count. But before a lesser non-included instruction can be given to the jury, the trial court is still under an obligation to find that there is evidentiary support for a jury to acquit the defendant of the greater offense and convict him of the lesser offense. So it's going to have to engage in some sort of factual inquiry in order to make that legal determination.
But isn't the trial judge's function there just kind of a gatekeeper function as opposed to an adjudicator? In other words, by that I mean, according to the Supreme Court, you don't need much for the defendant to be entitled to the instruction. If the defendant presents some evidence, then it's up to the jury. And my question is, why wasn't it up to the jury here? It may have been implausible, but why wasn't it up to the jury to decide whether he was in custody or not when he ran away?
Well, I think it also, and tell me if I'm not answering your question, but it depends on how this court is looking at the instruction. My argument is that this is a lesser non-included instruction. I understand that a lesser non-included instruction has been analogized to a theory of defense instruction, and that's a much lower burden that the defendant needs to meet. It's just any evidence to support the theory. But for a lesser not included, there's an additional burden on the defendant. And I don't think it's just some evidence. I think that the court still has to look at whether that's some evidence or whether there's some evidentiary basis that provides a rational basis for the jury to acquit the defendant of the greater offense and convict him of the lesser offense. And here, it's very clear that the facts are not in dispute of what occurred between when the defendant was contacted in the apartment up until he gets to the patrol car and then runs from that officer. So I don't think the court took away anything from the jury. The jury was still able to determine, and did determine, that the defendant was in custody for the purposes of escape. But the defendant failed to actually show why he was entitled to that lesser not included instruction.
Well, if it wasn't an escape, wouldn't it necessarily be resisting arrest?
Not necessarily.
Because it could be neither, you're saying.
It could be neither. I think it could,
Under what circumstance here?
where it wouldn't be resisting.
Yes. If whoever the fact finder is determined it wasn't an arrest.
They could find that one of the other elements of resisting wasn't met, including that the defendant used any means other than using or threatening to use physical force or violence against the peace officer, which created a substantial risk of causing bodily injury. It's unclear from the record. If I remember right, Officer Rojo testified that he wasn't sure if he had to dodge cars. They did run across the street, but potentially the jury or fact finder could find that that element wasn't met.
On the escape charge, the habitual, I gather you contend the statute clearly says that that type of escape charge can be the triggering offense for the habitual?
Our position is that under a plain reading of the statute, looking at subsection 5, which is the escape portion, and then subsection 2, which is the big habitual subsection, that based on those subsections, that escape can be used as a triggering offense, but not predicate.
Following up on Judge Miller's question, given what the legislature said they were doing for the amendment, which clearly wasn't in place here, but doesn't that really take away a lot of the steam of your argument that that's what was originally intended by the legislature?
I don't think that this court gets there unless it finds that the statute as it was in 2012 is ambiguous. So if it's clear from its plain language, then this court doesn't look beyond the plain language to the legislative history, to the change in the statute. However, I do think if this court finds that the statute is ambiguous, then that is something that the court does get to take into consideration.
Well, if we were to take it into consideration, it's pretty much dispositive, isn't it?
Arguably, yes, because I think the language based on that 2017 amendment is clear.
Well, let's talk a bit about plain language of subsection 5. You're saying that you contend that the plain language applies only to prior convictions, right?
Yes.
And the statute says, a conviction for escape shall not be used for the purposes of adjudicating a person an habitual criminal. How many convictions are there that are used for the purposes of adjudicating a person an habitual criminal?
It would depend on how many felonies the person was convicted of.
Well, for one, he was convicted of the current felony, right?
Correct.
And that is absolutely necessary for him to be convicted of that first one for the purposes of adjudicating him an habitual offender, right?
Yes.
And then it's absolutely necessary that there be priors, right?
Yes, I agree with that.
So explain to me how the plain language only applies to the prior convictions.
So our argument is looking at subsection 2, which is talking about what is required to adjudicate a person as a habitual criminal, describes what's required, which is that it's 3 or more previous felony convictions separately brought and tried and arising out of separate and distinct criminal episodes. And that based on that this is a sentencing statute, as well as that language, that's what is required in order to sentence the defendant as a habitual criminal. That's the plain reading of the interplay, I guess, between subsection 5 and subsection 2.
But he still has to be convicted of the current conviction, or
He-
current offense,
Yes,
and obtain a current conviction
yes,
to go along with the priors.
yes, because if he's not convicted of escape or whatever the felony conviction was, then obviously this sentencing habitual statute's not in play.
Right. Okay, thank you.
If we reject your position and hold that Mr. Jompp can't be sentenced as a habitual offender on the escape charge, what do we do regarding our remand order on sentencing?
My position is that it would be remanded only for resentencing on the escape. Defendant's not challenging the habitual finding as to the robbery. So it should only be vacated and resentenced as to escape. And I agree with counsel that it could be concurrent or consecutive, that would be up to the trial court upon resentencing.
I think Mr. Lacefield made some comment about, in answer to Judge Berger's question in that regard, that if sentencing on the escape charge had an impact on the court's imposition of sentencing or sentences on the other charges for which he was convicted, then possibly the court would be able to reconsider all the sentences. First of all, how do we know that, and how do you respond to that?
I think that in this situation, the court didn't have that discretion on the robbery count because the robbery count was also sentenced as a habitual, the defendant was also sentenced as a habitual criminal on the robbery count. So the court was required to sentence the defendant to what it did. So I think that sentence has to remain because it's not being challenged. I mean, that's not being challenged on appeal. But then obviously for the escape, that's then open to the court to do what it sees appropriate.
What about the other sentences? I think there was a sentence on a third-degree assault. Would that be open to resentencing if we remanded on the escape conviction?
My position would be no, unless there's something, and for some reason, and I must be mistaken, I thought he was only convicted of robbery and escape, but if there was the misdemeanor conviction as well, then I think unless there's something indicating that the escape played into that, then it remains that it's just resentencing for the escape. If the court has no further questions, I thank the court for its time and would ask the court to affirm.
Thank you. And counsel, you have 2 minutes and 54 seconds for a rebuttal.
Thank you, Judge. First, as to the speedy trial, I would direct the court's attention to Marquez v. District Court, 613 Pacific 2nd, 1302, pages 1303 and 1304, where the Supreme Court says, and the trial court failed to make corresponding findings. The burden, talking about the state's burden and the court's burden, it says, this includes making a record sufficient for appellate court to determine statutory compliance. And in reversing, it says, nor did the trial court make specific findings establishing the statutory elements for our review. This is the language from our Supreme Court in Marquez, which the trial court here failed to comply with. Also, the remedy in Marquez and Abeta was reversal and to remand for dismissal with prejudice, not for a remand. As to the lesser non-included issue, Your Honor, it's a multi-step analysis. First, there has to be some evidence viewed in the light most favorable to the defendant. If that standard isn't applied as a threshold, then you have the trial court sitting as fact finder and replacing the role of the jury. I don't dispute that you also have to prove a rational basis to acquit on the greater and convict on the lesser. But what this court did, or what the trial court did, was took from Mr. Jompp his right to seek a compromise verdict and not force the jury into an all or nothing proposition, which our state Supreme Court reaffirmed as recently as this past year in Naranjo. And finally, Your Honor, as to As to the resisting, Your Honor, Mr. Jompp was proceeding under 18.8103 sub 1 sub b, which refers to using any other means which creates a substantial risk of causing bodily injury to the peace officer or another. He ran across a street, and I believe the testimony was that they couldn't recall whether there was traffic or not. This creates that risk. So all of the other elements of resisting arrest are satisfied. In response to Judge Berger's question, if the amendment doesn't apply as clarifying and it's considered new, if it's considered an amendment that changes the law, then I believe that Mr. Jompp would still be entitled to relief under our Supreme Court's recent decisions in People v. Stellabot and People v. Patton. This change was an amendment to the sentence that's been imposed, and his conviction is not yet final. So for those reasons, I would ask the court to reverse and remand for dismissal with prejudice or as alternatively requested.
Thank you, counsel. Thank you, Mr. Lacefield and Ms. Rossbaum, for your excellent and helpful arguments. Those arguments will indeed be helpful to the division in reaching a decision. The matter will now stand submitted, and an opinion will issue in due course. Thank you, and counsel are excused. And as soon as they have vacated counsel table, counsel in the next case can come forward. And do council have any questions about our practice and procedure before the court? And if you would identify yourselves and give us your bar number when you begin, we're ready to begin on case number, it's Herrera versus Lerma, case number 2017-CA0991.
May it please the court. My name is Damon Davis, counsel for Maria Herrera. My attorney number is 34323. Excuse me. This court should reverse and remand for a new trial on damages because of the errors the trial court committed in admitting and excluding evidence, in instructing the jury, and in limiting voir dire. First, I'd like to address why the impairment rating was relevant and admissible under Rule 403, and then turn to why giving the aggravation instruction was erroneous, and if there's time, turn to the other issues. First, the trial court erred in excluding plaintiff's impairment rating. Permanent impairment in Colorado is a separate category of damages a plaintiff can collect in a personal injury suit. This makes evidence of permanent impairment relevant in a civil trial. And an impairment rating is an objective, medically recognized quantification of the amount of permanent impairment an individual has experienced due to injury or illness. Here, the trial court ruled without explanation that the impairment rating was irrelevant. This ruling was an abuse of discretion. Having an objectively measurable amount of impairment is relevant to showing the existence of physical impairment, permanent impairment. It makes it more likely to exist. Additionally, having a quantifiable amount of impairment assists the jury in determining the damages that should be awarded for permanent impairment.
Excuse me, a couple things. One, the expert did testify that she had a permanent impairment. Am I correct about that?
Yes, expert did testify to permanent impairment, but couldn't testify to the degree or the rating.
Did she say anything like it was substantial or?
I don't remember the exact language she used. She said that she did determine that there was physical impairment, but she wasn't able to put a quantification to it. She wasn't able to say this is the amount of impairment that she had.
And did the expert allocate that impairment between the two accidents?
No, I believe the expert had put it all for the first accident, the 2012 accident.
Okay.
So what we're really talking about is the relevancy of the percentage of
Yes,
impairment, because the court did determine that the fact that she was physically impaired was relevant.
Yes, the fact that she was physically impaired, the expert was allowed to say that, but what you have with the impairment rating is you're able to quantify and say, look, it's one thing to say qualitatively she has permanent physical impairment. It's another thing to say to the jury, she has permanent impairment, physical impairment, and we can measure it, and we can put a number on it in a scientific, objective, reproducible way. And that was what was left out in this case, that the expert wasn't allowed to testify to. And having that objective quantification of impairment was critically important here, where one of the defense's main arguments is the plaintiff isn't credible. A lot of the closing argument was dedicated to saying that the plaintiff isn't credible, you can't believe her. Well, if you have an objective, quantifiable amount of permanent impairment, that not only makes the amount of permanent impairment more likely, that first of all, that it exists, makes the existence of an underlying injury more likely because you don't get permanent impairment unless you have an injury, and it also assists the jury in determining damages, and here the jury awarded nothing in permanent impairment. So it's critically important to have this quantification of the amount of impairment, especially in a case like this where credibility was such an issue.
How would the jury have used the percentage of impairment if they had been allowed to hear it? How do you, at this point, speculate how they would have used it? They would have applied 15% to what?
Well, it's consider 15% whole person impairment, which means you're essentially impaired to 15% of your ability that you would otherwise have. What the jury can then do is, it's up to the jury. I think this was described in the Tabiaros case, the out-of-state case, and some of the other cases. The jury can then say, well, look, this is how much your whole body, unimpaired body is worth. you're injured to this degree, so we think that amounts to X amount of money. That assists them in awarding damages. Now, it could be different for every person. People that are more physically active are going to probably suffer more injury from being physically impaired than others, but it's still a factor they can weigh in assessing the damages. And other states have looked at that and said, yes, that's very much an important factor in assessing the damages. And it also goes to the existence. The jury can say, look, you can talk all day, the witnesses, about saying she's impaired, but here they can actually measure it. They can measure and say, this is the degree of impairment, and the expert witness can explain how they did that. And in fact, that was one of the things the judge said, well, look, if you give this impairment rating, then we're going to have to get into explaining how you calculate it. Well, that's perfectly appropriate. That's what the expert should do, say this is how we measure the amount of permanent impairment, this is how we get to a rating. And to an extent, Dr. Price, plaintiff's expert, did a little bit of that. She just couldn't go into the numbers explaining what she arrived at.
Well, didn't she do everything except the number? I mean, she said, these are the reasons why I think the plaintiff is impaired. She did all that. So it seems to me your argument boils down to the incremental value of the actual rating, the numerical rating, was prejudicial, and I'm having a little difficulty understanding, maybe because I'm not sure what the legal standard is to make that determination. I'm having a little trouble understanding how it was prejudicial when all of this evidence about impairment the judge allowed in.
Well, you get into it comes in two factors. One, she's limited in, I think she testified that she determined loss of range of motion, but she wasn't, I don't think was able to give the numbers that she arrived at. I calculated this amount of loss of range of motion that came out to a particular impairment rating. It's critical in the numbers. You look at the juries want scientific evidence. They talk about the CSI effect, and juries want something that's quantifiable. I think that's where it really comes in. You have an objective measurement. You can say, look, don't take my word for it. Don't take a qualitative description. Here's a quantification. This is the amount of impairment she had. We can measure it. We can put it down as a number on it.
But are you, excuse me, are you saying that the judge prohibited the expert from testifying, for example, that the normal range of motion of a normal arm is X degrees, and she was only able to move it 20 degrees? Are you saying the judge precluded that?
I think it could be read that way. I don't think Price I think she said she measured loss of range of motion. I don't think she got into the percentages. I think there was a concern that would start to get into the rating and how you would use that loss of range of motion to derive a rating. So I do think you had an issue, or at least a concern, with whether she could get into that. So I do think you have an issue with both getting into the percentages and getting into the rating as depriving the jury of this important evidence, this quantification of the amount of impairment, both, again, to determine whether the damages should have been more than zero, but also to determine whether it exists. Because if you can quantify something, if you can put a number on it, that makes it more likely that that thing scientifically exists. I think that's true with the impairment rating. And you look at the music decision out of Florida, and they said excluding the impairment rating was an abuse of discretion because it was very relevant, and both in determining the existence of impairment and in putting a number on it, what would otherwise be difficult for the jury. So we would ask the court to reverse and remand for a new trial on damages on that basis. I'd also like to turn briefly to the aggravation instruction based on a subsequent event. And really, we have the subsequent 2013 injury. It's undisputed. The undisputed testimony was there were no injuries from this incident, no pain from this incident, no aggravation. That was the sole testimony at trial. Defense did not put on any contradictory evidence. Without evidence, you can't get the aggravation instruction. Defendant's sole argument is you have a 2013 incident, and then later you have a 2014 resumption of care. Since one followed the other, there must be some causation there. That argument relies solely on the logical fallacy of post hoc ergo propter hoc.
What does that mean?
Following this, therefore because of this. simply assuming that because one thing followed the other, there's a causal connection. That's not the case. It's a logical fallacy. Just because something followed another doesn't mean there was a causal connection. Is it possible that the 2013 incident caused some aggravation? Possible, but the Safeway Reeves decision says just being within the realm of possibility isn't enough. You have to have a probability. You have to have some sort of causal evidence, whether it's medical evidence, whether it's something beyond simply an injury following an incident. And this case is ultimately similar to the Brooks case. In that case, it was the plaintiff who sought the aggravation instruction. They wanted it based on aggravation of a pre-existing condition. He says, well, look, I had surgery on my back several years ago. I have pain in the exact same area. That's evidence of an aggravation. I had pain following this incident, and the court said, no, that's not enough. Just because you have pain in the same area doesn't mean it's enough to get an aggravation instruction. Instead, you have to have some sort of medical evidence showing this aggravation of your pre-existing condition. Same situation here. She has pain. She says she had pain ongoing from the 2012 injury, says no pain from 2013, doesn't seek medical care right after the 2013 incident the way she did in 2012. Nothing medical, no connection showing an aggravation. All you have is presumption of treatment following. Under this court's precedent, under Supreme Court precedent, that's not enough to get you the instruction. And it prejudiced the plaintiff in this case because defendant argued strongly in closing argument that all of the injuries, all of the subsequent medical care, the ongoing pain were tied to the second incident. But there's no causation evidence. And the fact that the jury awarded little more than the ER bill shows they may have been swayed by that argument. And as the court said in Brooks, if you give an instruction that's not supported by the evidence, that implies to the jury, well, there is some evidence of it, making it prejudicial in this case.
Can I ask you a quick question about
Yes.
one of your other claims? Did the plaintiff withdraw her claims for lost wages?
Yes.
Does that moot the deposition testimony issue then?
It doesn't moot the issue as far as the appeal goes because it's what results in the improper impeachment. Since she had withdrawn it, there was no reason to be, no rebuttal value to asking about her prior statement about whether she had lost work or not. So the sole purpose of that questioning was to impeach the plaintiff, but you're doing it through a different witness before the plaintiff ever had a chance to testify. And if you're going to impeach the plaintiff with a prior inconsistent statement, one, you have to impeach the plaintiff, you have to ask her about it, and two, you have to give her a chance to acknowledge and explain the prior, the inconsistency. And that wasn't done here. So she didn't have a chance to both acknowledge the inconsistency or attempt to explain it, and that ended up prejudicing
Didn't she
her.
testify after this?
She did testify after it, and it wasn't brought up as far as I recall in her testimony.
But it could have been brought up on direct, couldn't it, by the plaintiff's counsel?
It could have been brought up, but that doesn't.
If it was important to explain the testimony, that inconsistency, that could have been done when she testified.
It could have been done, but it still should have been, the impeachment still should have been done correctly, and it still didn't have any substantive
Well, what's the harm?
value. The harm, again, the harm goes into the effect on her credibility and questioning it, before she had a chance to address it herself, and she loses that ability to address it at the time it's brought up. I think that has a stronger impact on her credibility. That's, I think, has a negative effect on her. So for these reasons, the reasons set forth in the brief, we'd ask the court to reverse and remand for a new trial, and I'd ask to reserve the rest of my time. Thank you.
May it please the court. My name is Sarah Andrzak, attorney registration number 49037. I represent the appellee in this matter, Leo Lerma. The underlying trial, as you know, is about a motor vehicle accident and the claimed injuries and damages that plaintiff believed that she suffered as a result. The appeal is about 4 discretionary rulings that appellant cannot show constituted an abuse of discretion by the trial court.
Let me start right out on
Sure.
the voir dire. Didn't the Colorado Supreme Court in Smith versus District Court specifically hold that the trial judge has to allow precisely the question that was asked here by plaintiff's counsel?
Smith does stand for the proposition that you have to be able to allow the specific insurance question during voir dire. However, Smith wasn't presented with the option that this court ultimately went with, which is basically a 2-step process. That's what Davis addressed and what Davis held was acceptable. So you've really got, and Davis is a case that was cited by appellants in their brief as well. So you really have 2 Supreme Court cases that address this issue in 2 different ways, and both saying that they're okay avenues. The court here did not say you can't have this specific insurance question. It just said, well, before we dive in and we go that far, let's start broad and see if we need to get there. And in this particular instance, we have a substituted service case. There's already no defendant sitting with counsel, so I think there were some heightened concerns that were talked about with the court, and what the court did was reasonable to say, well, if you get a juror that answers affirmatively, raise the issue with me and we'll see what's appropriate at that time. I think if the court then had said, no, I disagree, we don't need to get a specific insurance question, then I think you'd have a violation of Smith and it'd be a different issue here.
So you think Davis specifically permitted the 2-step process that the judge used here?
I do. That's my reading of Davis, that it says you can start general, and then if there is an ability for the counsel to raise the issue of the specific question and they don't do that, then there isn't an error to be reviewed by you all, the division. So I don't see that there is an error in the way that the court approached this issue. I think it's actually a better way to approach it than Smith. Smith just wasn't given the opportunity to look at it in that aspect.
Well, during voir dire, if it's my recollection of the record, that plaintiff did ask the general question that the court allowed him to ask, and there was one response.
That's correct.
And that response had nothing to do with Young America or the insurance company involved with the defendant. Was there any follow-up after that by plaintiff's counsel? And I can't remember, Mr. Davis, if you were counsel or not at trial, or trial counsel. Was there any follow-up after that to ask another question or want to go further, or ask the court, well, can I ask that question I wanted to ask?
There was follow-up by plaintiff's counsel to the juror without asking the court for that follow-up, actually. Another series of questions happened when it said, you know, what's your experience? Have you handled any claims? Have you done this or done that? And so there were some additional follow-up questions. The specific insurance company was never named, but I believe, counsel took an opportunity to ask additional questions and to see if a specific insurance question for Young America would have been appropriate. But 2, I think by the time they got through those questions, it became clear that that specific insurance question wasn't going to give any prejudice anyway. This person was an insurance agent. They didn't have any experience with claims. And so I think that's probably why they didn't ask for the specific insurance question, but regardless, they didn't go there. And that specific juror was ultimately excused for cause on a separate issue. There's no other juror that appellant can point to that says that this would have affected the decision-making process down the road because, you know, X, Y, or Z juror could have had this connection to Young America.
My understanding of the record is that the general question that was asked did not ask people if they were policyholders of an insurance company. Is that correct?
I believe the question did include policyholders. I have, no, I have agent, stockholder, or employee is the question that plaintiff's counsel phrased to the court and said, this is what I want to ask.
So the plaintiff never asked for the ability to inquire if people were policyholders, right?
Correct, that's what I have, and I'm looking at transcript 31317, pages 2 on lines 22 to page 3, line 1, is where I have the insurance question that he asked for. I do want to talk about the impairment rating if there's no other questions on the voir dire issue. The proper standard is abuse of discretion. The court order mentions where the impairment ratings come from and talk about that statute extremely briefly, but the ultimate analysis is under the rules of evidence 401, 402, 403. And the impairment ratings are created for the limited purpose of finding a number to give someone in lieu of wages. There's nothing in the statute about how it applies to personal injury cases. There's no wage loss claim in this case at trial. There's no connection to workers' compensation benefits. And it's
Well,
reasonable.
I don't think that's even disputed.
Okay.
To my recollection, I don't believe plaintiff was saying that this was in any way a wage compensation case. I think the question is, just because the impairment rating is used in the workers' compensation context, does that make it irrelevant in an other type of personal injury action? And I see here that the plaintiff asked for damages based upon permanent impairment. So that's part of their claim. So tell me why the percentage rating of plaintiff's impairment, permanent impairment, is not relevant to a claim of that nature.
It isn't relevant because the purpose behind coming to the rating isn't present in the case. If impairment ratings were given by all doctors everywhere, no matter what, it would be relevant. It would have a purpose in workers' compensation, but would also be seen in personal injury aspects of medical treatment, and that's not the case. You go to a specific doctor and you request an impairment rating for a specific purpose to compensate. So it isn't relevant to that extent. Also, I think your question really touched on the heart of our argument is, so you give them a number rating and what are they going to do with it? It isn't relevant to answer the question that's before them is, what is this person entitled to for impairment? A rating number doesn't get them there. All of the objective measurements do, if there's range of motion loss, if there's anything else that's measurable, all the bases for the opinion that Dr. Price was able to give, that's all relevant, that's all admissible, but the actual rating doesn't do anything to assist the jury in getting there. If you have 15%, what do you do with it? So it isn't relevant for that reason. Also, impairment ratings are challenged all of the time. It's something that happens in workers' compensation.
Well, did you challenge it in the trial court? Did you have an expert? Did defense have an expert come in and challenge the impairment rating?
No. But for the sake of responding to appellant's argument that these are scientific, objective measures, they're not. They're subjective. That's why they're challenged in workers' compensation so much. And the things that are objective, the measurements and the examination that's done by Dr. Price that she can testify to, that's all the things that are properly before the jury and relevant to be considered.
Well, the fact that it's subjective, there's nothing in the rules of evidence that says that subjective considerations are per se inadmissible, are there? Is there anything in the evidence code that says that?
No, I mean, expert opinions are always going to be, to a certain extent, subjective. You're looking at evidence and you're making a determination, but the relevance of just a number that a jury has nothing to do with after, it would be extremely minimal, which leads to the confusion of the issues concern that the trial court had. And I think if you are looking at this in the proper standard of review, which is abuse of discretion, Trial courts are doing this all the time. They're excluding the evidence because they're seeing these issues or trying to preclude these issues from happening in their trials. And so for the trial court to look at these other orders and say, well, there's an increasing trend that these are being excluded, there is a danger of confusion, and the relevance is minimal, it's not an abuse of discretion to exclude them.
What's the danger of confusion?
Yeah.
If you have I think it confuses the issues of just what this rating is and how you work with it. If you gave me a number and said 15%, I'd say 15% of what? So I think it is confusing to a jury.
Well, on the other hand, it might be helpful to a jury, other than just say, yes, this person is physically impaired. How does the jury deal with that? If you say it's 15%, that might be helpful to a jury, wouldn't it?
I think it can be helpful. I don't think that it's so helpful that it would trump everything else that's these other orders that are, courts are agreeing that this is an issue. I mean, the real danger is that if you let this in for whatever reason, you're then going to have essentially mini trials on a workers' compensation issue. The danger is that you open the floodgates to talk about the guides that are mandated under the statute to be followed and how the rating is created.
Why would you get under the statutes to be followed? Why would that be relevant?
Well,
I realize you get into the guidebooks, but you can impeach it. I know you were saying there's confusion between the third and the fifth and the sixth, but that's something that people cross-examine experts on all the time. I don't understand why we would even be talking about the statutes.
Well, if I have an expert providing an opinion and I want to know why they're doing that and where that came from, and in this instance, Dr. Price, there was a note in her expert report that she may or may not have been using the correct revised version to come to the rating that she said that she came to.
Sure, and you can impeach her on that.
Right, but you still open the door to, then you have to get into the guides and why the rating is calculated and what it's typically used for. And if you have someone who has an underlying workers' compensation claim or any relation to that issue being pursued elsewhere, then you're going to have a mini trial essentially on all of the workers' compensation aspects of the case that really don't mean anything from a personal injury standpoint.
That's not in this case, right? She didn't have a workers' comp.
No, that is not. I'm simply trying to say that for the implications of allowing impairment ratings or finding that it would be an abuse of discretion to exclude them would be dangerous in terms of its opening the floodgates to these other issues.
Go ahead, Judge.
Couldn't the use of a percentage of impairment rating be helpful to the jury to determine just how much of the requested damages plaintiff has made a request for, how much they're going to award? Let's say there's 15% impairment, like in this case, and in another case, there's an impairment of 50%. Or let's say there had been an impairment rating of 50% in this case. Couldn't that have an impact on the jury? Couldn't the jury say, well, she's asking for damages for impairment, and 15%, we don't think that's a whole lot, but 50%, now that's quite a bit more, and we might consider awarding her more damages on a 50% rating than on a 15% rating. Isn't that helpful to the jury?
To an extent, because it's a percentage, so I can see where a lower percentage versus a higher percentage is showing a different amount, but I don't see that as a more helpful, it's a way to make it easy for a jury, but I don't think it's the most intuitive and beneficial way to do it. I think the beneficial way is to look at the actual evidence and say, she's got these issues, this is where they're seeing the impairment, this is how it's affecting her, what is that worth? And if someone is saying, well, they're 50% impaired, so what do I apply that to? The claim for permanent impairment? Do I give 50% of that? Do I say, oh, I agree with 50%, so I award all of it? I just don't think it's a practical, there's no mathematical formula for it to be plugged into the way that it is in workers' compensation.
Before you run out of time, did you present any causation evidence that would justify the trial judge's instruction on the second accident?
The causation evidence would simply be the two witness testimonies that testified about the accidents, and there's similarities. So you have 2 motor vehicle accidents involving an acceleration of speed into a stopped vehicle, which is the same mechanism of injury, but plaintiff did not.
But don't
Go
the
ahead.
cases that Mr. Davis cited say that's not enough? You have to have some direct causation evidence?
I don't find appellant's citations helpful. They're not on point with the issues here, like the Safeway case that was referenced. That's not about a jury instruction, it's about a dismissal of a complaint. Yes, there has to be some competent evidence, that's the standard, but especially in this case where a plaintiff did not tell her doctor she was in a second accident. So at what point are we able to present evidence of causation when plaintiff hasn't disclosed this to the people that can make that determination? And plaintiff has the ability to rebut that instruction or rebut any evidence presented through plaintiff or the other witness that was involved in the accident to say, look, they don't have causation. They didn't bring before you the investigating officer or anyone else involved in the accident who observed her at that time. But it's still an issue that needs to go to the jury to say, the second accident happened and all of the treatment, nearly all of it, happened after that. And so the jury needs to be the fact finder. I'm out of
See,
time
your
by a
time
lot.
has expired.
Yes, I'm sorry.
Thank you.
Thank you so much.
Counsel. And bailiff, if you would put in 1 minute extra on Mr. Davis's time so that we're equal in time here.
Thank you, Your Honors. Turning to briefly the voir dire question, I would point out, first of all, the Davis case that my colleague referenced predates the Smith case. So if anything, the Smith case being the newer authority would govern the issue. And additionally, in the Davis case is distinguishable because the plaintiff never bothered to find out who the defendant's insurer was in that case. And I believe that was before mandatory disclosures. I believe it was in the 1960s or late 50s that case went to trial. It was, I think, a 64 decision, if I remember correctly. So they didn't have to disclose that, so they never bothered to find out who the insurer was. So you had to ask the general insurance question to start with. You didn't have another option, whereas once you get to Smith, you have mandatory disclosures as who the insurer is, so you get to ask who the specific insurance question, and you get to ask about that. So Smith is really the controlling authority there.
Mr. Davis, I know this is in rebuttal and I'm taking up your time, but I didn't get to ask you this in your original argument. How was your client prejudiced by the court's ruling with regard to the voir dire questioning when you were able to ask the general question and no one answered except one person who had nothing to do with young America? How does that prejudice your client?
I think the risk you have with not asking the specific question is triggering the jury's memory with, are they going to remember? If you had a short stint with young America, people switch jobs more often. If you have a short stint with them, or you own shares in their company for, maybe you owned it for 6 months and you sold them, what have you, that you forget about that if you're just asked a general question, whereas if you were asked a specific question, you might recall. Just briefly, on the impairment rating, the fact that it's used in workers' compensation has no bearing on a civil suit. You use lots of types of evidence in work comp, also use them in civil suits. It just doesn't matter. So I'd ask to disregard that line of theory and ask you to reverse and remand for a new trial. Thank you.
Thank you, counsel. Thank you both. Thank you for your helpful arguments. Those are definitely going to be useful to us in reaching a decision in this case. And the matter will now stand submitted, and an opinion will issue in due course. So that concludes our docket for this afternoon, and we appreciate you being here. And you're from Grand Junction, correct? Were you aware of our remote oral argument procedures or pilot program that we have in Grand Junction?
I was aware. I have used it a couple of times.
Okay, good. All right. Thank you, counsel. We appreciate it. Counsel are excused. The bailiff may announce the court in recess. All right.